There's one thing that I can't stand. That's quite something. There's a lot of things I can't stand, but right up chief among them are smugness and misplaced arrogance. And this guy's got both of those in serious volumes. It's the whole blasé attitude to everything, the holier than thou, and I know everything and you know nothing. Check this guy out.
Your Honor, I appear for arraignment only on behalf of my client, seek counsel, and that reason being that he intends to retain his private attorney. Please state your name, sir.
Jonathan Reeves.
All right, and so today's the date scheduled for the arraignment pre-trial in this matter, and sir, have you been here before? Yes. And so what were you here for? Yes.
Disturbing the peace.
Currently on probation or anything? No.
That case was completed, is that correct, sir?
Yes.
Okay. And are we continuing with the arraignment and then you want to retain counsel for the pretrial?
That's correct, Your Honor. We're asking for adjournment of the pretrial, and we're ready to arraign him today. He's allowed me to do that, representing in that aspect. If the court pleases, if not, we can adjourn the whole thing.
Well, no, we're going to continue with the arraignment, but sir, it's been 2 months and you haven't retained counsel before now?
No.
Okay.
Just for clarity, Your Honor, that when he was presented the paperwork to fill out for court-appointed counsel and his advice of rights, although I did advise him orally of his advice of rights, he did not choose to sign the paperwork or completely fill it out because he didn't agree with a lot of the things that are on that paperwork. So he's not applying for court-appointed counsel. He wants to retain his own attorney. Is that correct, sir?
Correct, sir.
Okay, but you also didn't want to sign your advice of rights either.
Correct.
Sir, the advice of rights is a document that shows that you have been informed of your rights in a criminal matter.
Okay, I'm aware. I did not agree with section 12 and I did not want to sign it.
Section 12 is telling you what it says: federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver, if you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. That's just stating what federal and or state law may prohibit someone from doing if you're convicted of a misdemeanor crime of violence, which you're not charged with one of those. So it's something that's required to be on the advice of rights form, sir. So you don't necessarily have to agree or disagree with it. That's just stating what federal or state law may prohibit someone from possessing if you're convicted of a misdemeanor crime of violence.
And they tried to explain that to me, but I still did not agree with it and I chose not to sign it.
Okay. Well,
I'm told him going forward to discuss that with his private attorney and then make sure that he understands all of his options in this case, including all of his constitutional rights.
Like, whether you agree with it and sign it out of agreement or not, it's still your advice of rights. So it's just a piece of paper explaining to you what those mean. It doesn't mean that you have to even understand them, but just sign it to show that you have been provided those advice of rights.
And have you already been in contact with attorneys, sir? So as to see who it is you're going to be retaining?
No, not this time.
Okay. So one question I have then, sir, is if you want to retain counsel, why haven't you made steps to retain counsel up until now? When you've had notice for 2 months of this matter. Well, actually a month.
I haven't had the funds. I haven't had the funds to make that happen at the moment.
Okay.
I've been working a new job. I've only been at for a couple months.
He's working now, Your Honor, full time as district manager for Taco Bell.
All right. And so the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, And we will adjourn the pretrial to December 13th. At 9 a.m. All right, so when you retain counsel, sir, please make sure you're advising them of the date because it won't be adjourned again. All right, and so as to bond.
Your Honor, my client tells me he's not on probation or parole presently. I've told you about his full-time employment. Your Honor, he has joint custody. Yes, yeah, joint custody of his three children, and he's supporting them, Your Honor, and he's on. Is it a court order child support?
Yes.
So, Your Honor, he's not a flight risk. This is not being a crime of violence. He's very interested in defending himself in this matter, maintaining his innocence. He is going to timely get a lawyer for next time. Is that correct, sir?
That I represent myself.
Okay.
These charges I feel are ridiculous, and
talk about the
wasting
facts.
court and my time.
Not talk about the facts of the case, but we're going to be back on 13th, Your Honor. So we ask the court to consider a personal bond in this matter, or bonding could reasonably expect a post.
Okay, and so the matter that you had before this court, you successfully completed probation on disorderly conduct. Was that reduced from something else?
Yeah.
What was it reduced from?
Originally, she was trying to charge me with domestic violence.
Okay, the name sounded familiar. That's why that seemed familiar. So, what is there a Third Circuit Court matter?
I'm sorry?
Is there a Third Circuit Court matter regarding any parenting time, custody, anything like that?
No.
No. There's an order of custody?
Yes, I have my children 3 days a week, and she has them the other 4.
Okay. And so how do the parenting time exchanges go?
Normally, if it's a weekday, I drop the children off at school. She picks them up from school or last week. And then same thing with her. On the couple days a week that we do meet in person, we meet at every police department. Which is where this allegedly takes place.
All right. So the court's going to order a $5,000 personal bond not to possess and consume any alcohol or drugs unless prescribed. And I'm going to indicate no assaultive, threatening, harassing, intimidating contact with Miss Courtney Reeves.
Yes, and then, sir, you can still have contact
I
with the exchange
understand.
of children, but nothing assaultive or anything to put her in fear. Do you
I
understand
haven't
that?
had any contact outside of my children with her in 4 years.
Okay. All right. We'll see you back on December 13th at 9 a.m.
Thank you, Your Honor.
Thank you. Have a good day. All right, this is the matter of...
I get it, dude. You feel hard done by. But being smug isn't the way to do it. Being kind of arrogant. You clearly showed that you need a lawyer because evidently you do not know what you're talking about. You're kind of veering into soft-sit type territory. And we all know that those guys know absolutely nothing. Have a look at one of the videos linked after this one to see what I'm talking about. Now, maybe the guy's done nothing wrong. I'm not saying he has or has not. It's just the way that he's dealing with it seems like a bit of a dick move, truth be told. Anyway, lads and lasses, if you thought that he was smug or arrogant, you let me know down below. We'll catch you in the next one. Sláinte. Good evening, everybody. The Irish Demon here, back with another video. And today we have a sovereign citizen in Judge Shackelford's court, and it gets pretty hectic. Now, if you like this kind of video, make sure and smash that like button and subscribe so you don't miss any more in the future. But this isn't just any soft-sit, guys. This is the infamous YouTuber Broken System, Broken Trust. And he threatened Judge Slavin not so long ago. And here's a clip from my good friend Colin, definitely not Cromwell's YouTube channel, showing just that.
So, you know what? You want to make threats against me? Listen, sir, you would never be able to handle a threat against me. I'm just telling you. Just telling you. So goodbye. Goodbye. Goodbye.
You're believing what?
Bye. So when people make threats against you, I'm just going to tell you right now, anybody else who's watching out there, I don't take threats very kindly. And you know what? I take them very seriously. And you know what? As a man, as a free man, as a man who is an American, I know what my rights are. and I exercise my rights. Freedom of speech, that's one of them. I like freedom of speech. Freedom of assembly. I like to hang out with people who I like to hang out with. Good people. Good, strong people who are, salt of the earth. People like Mike Tinney. Good friend of mine. I also exercise my Second Amendment right. And I'm well aware how to do so. So, I highly suggest you don't make threats against me. Because I do have a right to defend myself. Everybody out there watching, have a great rest of your day.
Please take your hat off. Hats off. Thank you.
Sure. No recording device. It's not a live stream. Okay. No recording device. Just outside.
All right. All right, Mr. Lanto, can you come on up?
Hello.
Hello. This is the City of Taylor versus Joshua Lanto. You're at this table, sir.
Okay.
Mr. Greco, can I get your appearance?
Yes, Your Honor. David Greco here on behalf of the City of Taylor.
Mr. Lanto, can you tell me your name?
My name is Joshua Lanto.
Okay, thank you. All right, so today is the time and date we had set for a trial. Mr. Greco?
Yes, Your Honor. As you are aware, this case was apparently transferred to you within the last month or so, I believe. I've been the prosecutor handling this case. I was aware of the transfer, but was not aware of the jury trial date scheduled for today. It had gotten assigned to the other prosecutor, Mr. Zick. I was not aware of this until late last week, was not able to get everything together to contact my witnesses and let the court staff know earlier in the week that
Well, then I motion that we.
I would not be.
Hey, if
So
you'll get a chance to respond, sir, wait for your turn.
And we're off to an absolutely blinding start. Soft sits. When you act like a child, you get spoken to like a child.
So I'm requesting an adjournment, as I honestly did not know in time. I knew of the transfer, but did not know of the date scheduled until I was contacted by the other prosecutor last week. And then, as you know, I contacted the court staff, letting you know that I would be the one holding on to the case and that there was no way for me to appear today or the witnesses.
All right, thank you, Mr. Greco. Mr. Lanto?
I've been here about 10 times now. I asked at the very first proceeding if I have the right to a fair and meaningful hearing. Do I have the right to a fair and meaningful hearing?
I am not going to play games with you, sir. Do you need to make a motion? Is there something you want to tell me?
I have a simple question for clarification, very simple.
I'm not
Do I have the
answering your
right-
questions. I am here to conduct a jury trial today.
Me
The
too.
prosecutor has requested an adjournment, and I am asking you what your response to his request is.
Okay, well, it seems like you're getting really angry.
Oh, I'm not. I'm being stern with you because
Well-
I'm asking you, sir, if you cannot answer my question, do you have a response to that?
Do I have a response to what he just said? I just want to know if I have in order to respond to that, what I need to know is, do I have the right to a fair and meaningful hearing? That's it.
Well, do you want an attorney that can advise you of your
No,
constitutional
I
rights?
want to know from you because you are presiding over this matter.
Sir,
I can't come in here and watch a trial.
there is no trial, sir.
Oh, I'm interfering with public court? Really? I thought that, thank you, really? Yep. Really?
I mean, you know we're on YouTube, right?
Oh, I do.
Right.
And thank the internet gods for that.
So I'm
Do I have the right
asking
to fair and
you,
meaningful hearing?
sir, you are in my courtroom because there is an allegation against you that you threatened the other judge in this building.
Then why am I not charged?
Sir, I'm not a charging official.
know
I'm a
you're not
judge.
gonna-
Do you want to be held in
Yeah.
contempt of court today?
Well, no,
Mr.
if you're-
Greco, your motion is granted. The trial will be adjourned. This trial was put on a fast track when it was transferred to me
What does that mean?
so that we could address this and so that Mr. Lanto could have his date in court forthwith. I understand that I do not have the same prosecutor as Judge Slavin. And obviously, on a case like this, with a history like this, Mr. Greco wants to stay on the case, and that's appropriate. He was not given notice because the notice
Why
went
wasn't he
to
given notice
Mr. Zick, my courtroom prosecutor, sir.
So whose
That is
fault
why.
was that? That's all I'm asking.
Sir, it was a clerical error, if
A clerical
anything.
error.
Okay, your motion's granted, Mr. Greco. We will get you a new trial date, sir, and I'm going to let them know downstairs that that trial date continues. Will need to be fast tracked so that we can get you on the docket as soon as
I want to get this
possible.
resolved today.
Okay,
I want to get this resolved, and I have a few questions about the charging document that I was given. Can I ask about that without being thrown
You
in
can-
contempt?
sir, you can speak with an attorney. You have a right to.
I don't want to
If
speak
you
to an
want
attorney.
to
I want to
address
speak.
these matters on your trial date, I am more than happy to address your concerns.
You're more
But this
than
is
happy
not going
address
to
my
be a
concerns.
circus. This is not going to be the Joshua Lanto show. This is going to be a jury trial that is conducted with proper courtroom decorum and behavior. And that is how we will be moving forward. If you are respectful to me, we will get through this very quickly and efficiently. But I will not tolerate outlandish behavior in the courtroom. I will not.
Well.
And I don't know anything about you, Mr. Lanto,
Right,
nothing.
right. You don't know anything
I
about
don't,
me. Let the
I
record show
have
them that.
every indication, I have every inclination, and I have no reason to believe that I cannot be fair and impartial in this case. I have no reason to believe that, and we will conduct that trial, but we will have proper courtroom decorum throughout these proceedings. You have a constitutional right to an attorney, and it's my understanding at previous hearings that you have waived your right to counsel, that you want to represent yourself, and that is within your rights, sir. But you
Okay.
will do it, if you're going to represent yourself, the same rules will apply to you that would apply to any other attorney
You
that
are the,
appeared in front of me.
you are the chief judge, correct?
Correct.
Okay, so it appears to me like you're getting very angry, and let the record show the only one that's been given threats here is me. You've threatened me with contempt already.
Yeah, because you're acting like a big manlet inside in court. Why do they always have that meth voice?
Okay.
Right? And you
Okay.
expect me to, expect you to be fair and impartial?
Okay.
I mean, you're not gonna be able to even.
Is there
convince
anything
these
else?
guys
Okay.
that I've done anything wrong. You have a sign outside your door that says due to COVID, you're willing to put 6 jurors in a box with COVID. You have a sign out there that says COVID is dangerous. You're gonna put everybody in danger because you don't like free speech here in Taylor,
Okay.
okay?
All right, we're all set. This hearing's concluded. Sir, you'll get notice of that trial date in the mail.
Is
I
it-
will let them know downstairs to expedite this, and I'm optimistic that we can get you a trial date in February.
Could you please answer my question because I think it's a very basic logical.
All right,
and
we're all
very
set.
quick question.
Thank you. We're all
Thank you,
set,
ma'am.
sir. Thank you.
Well, there we have it, lads and lassies. It seems like a lot of these guys are finding themselves on the wrong side of the law. And I don't mean just in terms of the wrong side of the camera. These guys are getting locked up en masse at the moment. And it's not some government conspiracy to put First Amendment auditors and free speech advocates away. It's just them acting like a bunch of dickheads. Anyway, folks, I really hope you enjoyed the video. If you did, make sure to like, comment, and subscribe. And we will catch you in the next one. It's Lanto. Now, folks, while I was recording this video, unfortunately, I got the terrible news that Archangel, who was a subscriber to this channel and many others, and somebody that a lot of you will have known from the side chat and from the comment section and from Discord and stuff like that. Sadly, Archangel passed away. This was something that I wasn't too sure about. A lot of people had kind of mentioned over the past couple of days that Archangel was quite unwell, and it is very sad to say that sadly Archangel has lost the fight and has moved on. So may Archangel rest in peace. I would usually do a little bit of a whiskey toast to, bid them adieu, but sadly I'm about to drive, so I can't do that. But I'll probably be doing a live stream later this evening, and you can be damn sure that I'll be getting into that bottle of Glenlivet there and raising a toast for Archangel. So thank you so much for joining me. Feel free to leave your love down below for Archangel. I'm not sure if the family know about this channel or whatever, but in the event that they do, please feel free to do that, and we'll catch you all later. It's Lanto. Rest in peace, Archangel. Now, when you hear the name D'Artagnan McFarland, I'm sure you're probably picturing a French-Scottish musketeer. with his perfect tash and his rapier. But actually it's not, it's this fella with the silly pink hat, probably his little sister's silly pink hat. And he says some stuff to this judge that I highly recommend you never say. He tells on himself so many times. This is unbelievable. Anyway, folks, let's get stuck in. On guard. I'm sorry.
D'Artagnan McFarland.
I'm right here.
All right, Mr. McFarland, looks like you missed, a jury trial. Okay. And you want to virtually address your bench warrant for a jury trial?
I came. We didn't take a trial.
Is that right?
Yes, I came. When I came, I was late, and I came in there and you said you finna mark me down for not being there. And then like 5 minutes went by, you asked me what I want to do. You were like, if I do trial, we'll come back at 1 o'clock. And I like, nah, we're gonna get it over with. So I pleaded guilty because it was in person. And I pleaded guilty, and the lady came outside to talk to me. She said she'd be right back. And I stayed out about 30 minutes and I didn't hear nothing else.
Now, I'm no body language expert, but I think when somebody says something like, that means that they maybe don't believe you and what you said is likely untrue.
There's a lot about what you just said to me, Mr. McFarland, that doesn't sound like the way that it happened. I mean, I can't tell sitting here how it did happen, but some of that sounds like things that would not happen in my courtroom.
What D'Artagnan here said happened didn't happen so much that it unhappened things that actually did happen.
What I'm concerned about, I'll just be very upfront with you, is a driving without a license case with a hit and run charge where I can't get the defendant in for a jury trial. So I'm not sure that I'm gonna allow you to address this bench warrant virtually. Let me go have a little conversation about that, and I'll be right back.
Yeah, because the person came to court.
Sir, you'd be better. You wouldn't have a no bond bench warrant. You came to court and were here at the time I had jurors here. So you're just better off not trying to further address that. Okay, I'll be back.
I don't understand. I come to court. Ted,
I want to turn your mic off.
Sir, please, Mr. McFarland, please mute yourself, sir.
Yeah.
Mr. McFarland.
I want y'all to hear what I'm saying.
Okay.
I think we all want to hear what he's saying. And what he's saying is, I came to court, yeah, but you came late. That is, if indeed you did come in the first place. Because it seems like maybe you were telling porky pies.
Lady came to court. I came to court. Yes, sir.
All right, so you said you were going to take a plea that day, and then I told you to come back at a certain time, and you came back and you ended up with a bench warrant. Is that right?
Can you repeat that?
I just want to make sure I'm getting your story correct. And actually, why don't I put you under oath? Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury, sir?
Yes, I tell the truth, yes.
Okay, state your name.
D'Artagnan McFarland.
All right, go. You want to tell me what happened that day one more time, please?
Okay, that
Quickly,
morning
I have juries.
It was court. I came late. I parked across the street at Chick-fil-A.
Okay.
I mean, when I got in your courtroom, I was late. You already had called my name. So I said, I'm here. You finna mark me for missing court. So the lady, I forgot her name, she had glasses on. She asked me what I want to do. You like, if I do trial, it would be at 1 o'clock. I said, no, I just get this over with right now. And you said, what you want to do? I said, I'm guilty. I stepped outside to talk to the lady, and she never came back outside to give me any paperwork. Because the lady, for the hit and run case, she was sitting on the left-hand side. It was like on a handful of people in the courtroom. It was either Wednesday or Thursday. God come from work.
All right. So I can't speak to the lady, but I can tell you how I operate and why I'm finding your story to not be credible. Before I issue a bench warrant, if there, sir, let me be clear with you. You have a hit and run case. So you are accused, not saying you're guilty of it, but you are accused of hitting someone's car and leaving the scene of an accident. Well,
yes, and that lady
hold on. I know we're not arguing anymore. You're going to let me talk, sir. You're accused of hitting someone else's car and leaving the scene of an accident while driving on a suspended or revoked license. I had you scheduled for a jury trial, which means I had jurors here that day. You were late, you admit that. And that in and of itself may be enough. You were late that day. You said you wanted to enter a plea and needed to talk with some lady. I don't know who that is. But what I do know is that even if you had stepped outside the courtroom, and this is getting to my point about how I operate, 100% of the time, no exception in your case, sir. If you had stepped out in the hallway for some reason, before I issued a bench warrant, I would have instructed someone to go out into that hallway, call your name, and see if you're out there. We even might have waited a little time, but certainly I would have sent someone out there to look for you before issuing a bench warrant. And if I had given you any kind of instruction to be in this courtroom at 1 p.m. that day, I would have been clear with you right here in the courtroom that you needed to be back at 1 p.m. that day. Your bench warrant issued for one of those two reasons. Either I told you to be back at a certain time that day and you were not here, or we couldn't find you when you went out in the hallway. Either way, your case was set for a jury trial where I had summoned 18 DeKalb County residents in here to be the jury pool in a hit and run case. And under those circumstances, sir, I am not going to recall your bench warrant on a virtual calendar. You are welcome to contact my staff and find out a day that we are going to be in court, in person, in this courtroom.
I already came down there in person, man. Like,
I'm not disbelieving that you were here that day, sir. But I do know.
So what's the issue then? Like, if
the issue is, sir, that if I was not able to address no, stop arguing with me, sir. Stop it.
I'm not arguing with you. Have a conversation because you saying one thing, I'm telling you what's going on.
And that, dear D'Artagnan, is what we call an argument. It's when one person's saying one thing and you're saying a different thing, and they're contrary to each other.
You absolutely,
no. I'm there and I tell you I'm guilty.
Sir, your case did not end in a plea or a trial that day, and that's entirely your responsibility.
How I testified on the thing when you asked me, you called me for it. I said I'm guilty. You like okay, because you said something about trial. So not come back down here until 1 o'clock for this. Let's get it over with. I said I'm guilty.
Taking a plea involves a lot more than you just walking into my courtroom and saying I'm guilty. So
I didn't take no plea, man. I said I'm guilty. I didn't take no plea. I told the lady I'm guilty. I told you I'm guilty. Then the lady said, step outside, sign some paperwork. She never came back outside. About 50 minutes, so I left.
You left that day.
I don't have to rely on nobody or nothing. Like, this is old. Like, the lady came who said I hit her. I said I'm guilty.
All right.
It wasn't no plea or nothing. I said I was
I
just
need
on
you,
the stand,
sir.
whatever it was no crowd, no 1 o'clock.
Sir, I hope that the rest of, frankly, I can't remember at this point. I hope the rest of our interactions did not go this way. You know.
No, it didn't go this way. I said I was late.
Because
I was late that morning. And you were like, what you want to do? You said trial
because the problem is you're not listening to what I'm saying to you. And it has consequences. Like right now, you just want to talk and you don't want to listen to what I'm saying. What I'm saying to you is this, and you need to hear it. Your bench warrant is going to stay in place until you appear in my courtroom in person. You should call my staff to find out a day that we are going to be, and it's got to be an in-person calendar call appearance. You can come in person for motions on Monday. But you need to call my staff and find out a date and time you can be in my courtroom in person to address your bench warrant. Because that is the only way I'm going to allow you to address your bench warrant. Do you understand?
No.
Okay, well, I've just told you what needs to be done. And again, virtual address
this case is old, man.
Addressing bench. Okay.
And just like that, he dismissed the case for himself. Happy days, who'd have known that you could just do that? Well, you kind of can't. I wonder how this is going to turn out for you, bud.
Well, since he's left the call, I will just make this as just a general statement. Addressing bench, I do need the state present though, Mr. Webb.
I'm present, Your Honor. Yes, sir.
Addressing bench warrants virtually is a convenience. It is not required that I recall a bench warrant because someone appears virtually. And I've been really very, very permissive about this for months and months and months, just recalling bench warrant after bench warrant after bench warrant. But when I'm presented with a defendant who clearly who has just chosen to not be here any longer, he's on my calendar, so I'm going to address the case.
Yes, sir.
When presented with a defendant who has hit and run charges and driving on a suspended or revoked license and has a no bond bench warrant for failing to appear for a jury trial, and then proceeds to argue with the court, under those circumstances, I am not going to recall the bench warrant virtually. And that is my decision.
The state concurs, Your Honor. In fact, we would have asked.
No comment is needed because the defendant is not here anymore.
Yes, sir. Yes, sir. Okay. Sorry.
Again, he's on my calendar and he's chosen to leave court and I'm addressing the case, but I also don't want to hear anything from the other side at this point because I won't be able to address it.
Got it, Your Honor.
Okay. D'Artagnan, McFarland was that case, so the bench warrant will remain in place.
Well, there's a massive surprise. Looks like D'Artagnan and the other two musketeers are going to have to roll on back there to deal with this. Probably wasn't the best way to go about it. I mean, he may have had a better chance if he just said, Your Honor, I messed up, I missed it, I'm sorry, I will be there the next time. Who knows, he might have still gotten the warrant anyway, but it's a better option than lying, especially when the judge clearly knows you're telling your little porky pies. Anyway, folks, thank you so much for watching this video. I really do hope you enjoyed it, and we will catch you in the next one. Here we go, Stav's in the house.
Back on to continue your motions. Let's start with that motion regarding the jurisdictional issue. I'm denying that motion. What's your next motion?
Your Honor,
after jurisdiction?
it was not a motion.
Okay.
Unless and until the court can prove jurisdiction over I, Edward John, the living man, with the jurisdiction of an American state national, which is only the jurisdiction of the land, not the admiralty law, unless you can prove jurisdiction over me, the living man, then this cannot proceed.
Okay. Well,
now I know
district court has jurisdiction over individuals who drive in this county, and so I find we have jurisdiction over you, and it's irrelevant whether it's in capital letters or in lowercase.
No, Your Honor, I am not the name in the capital letters. That vessel is a trust that I have called back to the jurisdiction of the land, and I am the administrator of that trust. And I am also of the living man, the American State National. Are you familiar with the jurisdiction of the American State National, Your Honor?
I am familiar with individuals driving in Jefferson County being under jurisdiction of the district court, sir.
Your Honor, I was not driving, okay? Driving indicates that you're operating in commerce. I was not operating in commerce, okay?
Okay.
I'm not here to defend that at all. I'm not going to argue this alleged infraction. What I want is for your court to establish jurisdiction over me, the living man, who is not Edward John Hauser in all capital letters. That is a vessel that I own and control and has been placed on dry dock under the jurisdiction of the land, which is higher and above, beyond the jurisdiction of the sea wherein you operate. So let the court be known that I serve notice on this court and its public officials associated with this court that all my vessels are owed the general session law and public law and are not subject to any private statutory or municipal law administered by this court. So if the court needs more time to investigate my documents, and I will admit they are voluminous, and then I am willing to come back and go over this matter with you again.
I do not need more time, Mr. Hauser, and I'm going to swear you in. Do you swear that everything you're about to tell the court today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Try doctors a new one on me too.
I'm going to read the officer's report of what happened for purposes of this contested hearing, sir. And so you have 3 alleged violations. No
Your Honor,
valid
you have not demonstrated jurisdiction before you can move forward.
Mr. Hauser, I'm sorry, I let you speak without interruption. Now I'm going to speak, and then you can speak again. So you're charged with 3 violations: no valid operator's license with valid ID, RCW 46.20.015. You're also charged in violation 2, operating a motor vehicle without insurance, RCW 46.30.020. And number 3 is operating a vehicle without current or proper registration and license plate, RCW 46.168.030.2. Sir, I do find we have jurisdiction, and I do find that this is a contested hearing, and I'm going to review the officer's report of what happened. It says here, March 4th, 2023, at about 12:56, I was on duty in a marked patrol car equipped with overhead emergency lights. I was on routine patrol in the area of Irondale Road in Irondale, Washington, observing traffic through the posted 35-mile-per-hour speed zone when I observed the defendant's black-colored Dodge Dakota pickup eastbound along Irondale Road. The defendant's vehicle did not have a license plate visible on either front or rear of the pickup. I turned on my emergency lights and initiated a traffic stop on the defendant's vehicle as it pulled off Irondale Road onto 5th Avenue into the church parking lot. I identified myself as a law enforcement officer and contacted the driver of the vehicle and explained the reason for the stop. The driver was later identified as Edward J. Hauser, date of birth 7/21/45. I requested the operator's driver's license, vehicle registration, and proof of insurance. The driver, who told me I could call him Ed, initially did not provide his name and never provided his vehicle registration or proof of vehicle insurance throughout the contact. Ed refused to provide the requested documents, further advising it was his right to, quote, travel, unquote, identifying himself similar to a sovereign citizen. Ed provided me a packet of paperwork, further stating he did not have to identify himself or provide me any information as requested. I explained to Ed, operating a motor vehicle in the state of Washington was a privilege and not a right, further explaining it is unlawful for any person while operating or in charge of any vehicle to refuse when requested by a police officer to give his or her name and address and the name and address of the owner of such vehicle. Likewise unlawful for any person to refuse upon demand of such police officer to produce his or her certificate of license registration of such vehicle, his or her insurance identification card, which is a misdemeanor, RCW 46.61.020, Ed continued to stand behind his beliefs in which he had the right to quote, travel unquote freely. I was able to obtain Ed's full name off the paperwork he provided to me. I later was able to identify the correct registration to Ed's vehicle by the identification number on the vehicle dispatch. Later advised Ed's driver's license was expired and the vehicle's registration was expired on February 4th, 2022. Correct Washington registration B57933W. I recontacted the Ed and issued a traffic infraction 3A0204968 for the following offenses: no valid operator's license with identification, failure to provide proof of motor vehicle insurance, and failure to renew registration. This contact was recorded by Axon body camera. This narrative summarizes the events related to the investigation. The report may contain paraphrased conversations intended only as a summary. Details reported may not describe the exact sequence of events. During this investigation, one or more audio-video recordings were captured on body-worn cameras worn by Jefferson County Sheriff's deputies. These recordings were uploaded to evidence and
If there's anybody out
as they
there
may show additional
who
detail
knows
as
how
to
to get
exact
body cam
sequence and
footage,
sequence
hit
of
me
events.
up. Email
I
irishdemonarmy@gmail.com.
certify or declare under penalty of perjury under the
We
law
gotta
of the state of
find it.
Washington that the foregoing is true and correct. Place signed Jefferson County Sheriff's Office, Port Halleck, Washington, and Jefferson County. Date signed 3/4/23, Deputy Eric Morris. And that's all I have, sir. What would you like to testify to?
Well, Your Honor, you claimed that I am being charged with.
Volume, please, sir. I really want to be able to hear you.
Okay, well, Your Honor,
I can't do that.
you are making the claim, and the officer is making the claim that I am being charged with these crimes or these infractions, these alleged infractions. But
It's
what,
just a civil infraction.
Your Honor, the fact remains that I, Edward John, a living man with a legal, on the record status, legal status, as an American state national, am only under the common law. I do not fall under statutory municipal codes. All right? So before you can move on me, the living man, you must prove jurisdiction. Every court has to do that. In personam and subject matter jurisdiction. So unless the court does that, then we can't move forward. And so I suggest that you and your associates study my documents clearly so that you can understand my true legal status, which is outside of your jurisdiction. You operate on behalf of a fiction. I am tangible. And again, I'm going to bring up the Penhallow case where they conclude, and this is a Supreme Court case that has been around since 1795, and it has never been challenged. No government, as well as any law agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons, and contracts between them. So unless and until the court can prove that I am corporate or artificial and that I have a contract with whom you are acting on behalf, then you cannot move forward, and I insist that you dismiss this immediately.
Paper drop.
Thank you, Mr. Hauser. I understand that you are objecting to the court's finding that there is jurisdiction over you, just like it had jurisdiction over all the other folks that were here.
No, it's not just like that.
Excuse me, I'm speaking, sir, then you can speak. I do find we have jurisdiction over you. You have a right to appeal the court's finding, and you can do that within 30 days. Would you like to testify about the incident where the officer pulled you over for not having your vehicle license plate displayed? Because if you want to testify about that, I can hear your testimony.
Your Honor, in my legal jurisdiction, I don't even recognize yours. I am above your jurisdiction. All right. I'm not here to argue any facts of this case and come and fall under your jurisdiction by, word art or any other diversions. I'm stating my case that the reality about me is that I am a living man. I'm an American state national, and my jurisdiction, that is my original birthright jurisdiction that all Americans are born with, and it is taken away from us by the birth certificate, where they issue your name in all capital letters, and that is a corporate entity that is owned and controlled by the government, unless somebody steps forward and claims their ownership of it, which I have done, and I have demonstrated it, and I have put it all on the record. And by the way, if I'm wondering if you are willing to bet your qualified immunity by refusing my right to establish my jurisdiction and failing your right, your obligation to establish your jurisdiction over me, the living man, the American national. Now, I'm willing to do a continuance, meet with you again in the future if you need more time to study my paperwork.
Oh, condescending.
Because all of that is on the record.
Sir. I've read all your documents. So do you want to testify? I'm giving you a second opportunity to testify about the incident, and the court is going to make a determination by a preponderance of evidence whether or not you committed the 3 infractions. You can either testify about it, you can ask for mitigation, you could ask for a deferred finding. You are eligible for a deferred finding, or we can just, the court can go with what the officer said in his affidavit. So do you want to testify about the incident, sir? Or do you want to have a mitigation or a deferred finding, sir?
I'm not subject to your court, Your Honor.
Okay. Well, I have reviewed the officer's affidavit, which I read on the record. I do find that these infractions were committed. The total amount owing, sir, is going to be $1,263. And I guess the question is, do you want to pay that today, or do you want to set up a payment plan with the district court clerk's office?
Well, the question that remains in my mind is, where is the evidence of your jurisdiction to levy that fee on me, the living man, the American state national, out of your jurisdiction?
Okay. And again, sir, driving in Jefferson County is a choice you made. It's not a right, it's a privilege, and you have, by making that choice, put yourself in the jurisdiction of this court for driving infractions. So.
Excuse me, Your Honor, 49 U.S. Code 31301 definitions. Driver's license means a license issued by a state to an individual authorizing the individual to operate a motor vehicle on highways. This indicates, and since a motor vehicle is any conveyance used in commerce, then a driver's license is a commercial instrument. And I was not carrying any passengers, and I was not carrying any cargo. I was traveling. My liberty to move about on the public highways as part of the public, and I was exercising that right, and I was not operating in commerce. Let that be on the record, because that is the true definition of what a driver is, someone operating in commerce. I assume you know that.
All right, I do find that these infractions were committed: the no valid operator's license with ID, the operating a vehicle without insurance, and number 3, the operating a vehicle without a current and proper registration and license plate. And we're going to impose a total amount of $1,263. It's $559 for the no valid operator's license, $559 for the operating a vehicle without insurance, and $145 for operating a vehicle without current or proper registration.
Oh no, they cut the live. God damn, we were only behind by 20 seconds anyway, so we didn't really miss a whole lot there. Good afternoon, everybody. The Irish Demon here, back with another video. And it is a doozy of a soft sit. But this was sent to me by my good friend yet again, Colin, definitely not Cromwell. His channel will be linked down below. Definitely go check him out. I had a long day. I've been on the road since 7 a.m. and it is now nearly midnight. And Colin sent me this. I was dying to get home to see and make this video. I don't really have to say a whole lot during this one. This guy kind of says it all for himself. So check it out. I'll catch up with you guys at the end just before I fall asleep. You can probably see it in my eyes. I'm pretty darn tired. But here's the thing. If you'd like to hear a little bit more about what I have to say about this video and what my friend Colin has to say about this video, join us in the next couple of days for a live stream. I'm going to be doing a really special live stream. I just hit 50,000 subscribers and 10 million views on this channel. Absolutely huge milestone for me. Way above and beyond anything that I ever thought was possible. So I want to thank you all so much for that. And if you're watching my channel for the first time, consider joining the ranks of the Demon Army. Drop a like and make sure you subscribe. There'll be a lot more really cool stuff like this out there. If you want to help support the channel in other ways, you can get some epic Irish Demon merch down below. Consider leaving a tip in the PayPal tip jar or grab a super thanks. And super thanks again to all of you guys.
I am the living man. I'm not a man. I am a living man. Known by the name of that.
Sure. So listen, for purposes of communicating with you, I'm going to call you Mr. Martin. I can clearly see that you are a living man because you're talking. Most dead men don't talk. So, Mr. Martin, this is case 231510OT. People of the City of Taylor versus Eric Martin. Today's the date and time set for your motion for return of moped and also a motion to dismiss the cases. This is your motion, sir. Go ahead.
Have you read the motion already?
Yeah, I've read the motion. I'm just asking you, are you just going to stand on the motion that you filed, which is fine, you can do that. I was giving you the opportunity to make oral argument if you wanted to.
Right. Well, just first, I'm going to say on the so-called charge against me, I am entering a special appearance. Okay, that is in no way a general jurisdictional granting appearance. I challenge the jurisdiction of this court. The contract that I have knowingly, willingly, and voluntarily entered into with this court that grants any jurisdictional authority over me as a living man. If there's any such contract with the court, I demand the court present it. I also want to say I'm here by threatened arrest. I'm not here willingly. Like I said, threatened arrest is the normal. If you don't show up, arrest warrant, etc. Now in response to what to say about the motion. As a recap, okay, my motions are all based on my and the reason first I want to point out the reason I don't like using the word motion because I know that tradition I use the word demand because it's based on the Constitution, right? My human rights. So how I've been taught in the law, these are the words I like to use. If I use the word request motion, that's not right because you request privileges. You demand right. That's how I've been taught. So that's how I learned. So I just want to say that, I don't want you to take it personal or nothing like that. Hopefully, it just demanded my right. But I want you thinking, hey, I'm the judge here. Who are you to demand? But it's demanding rights. But anyway, so again, it's based on my right to private property, my due process. Which is in the due process of the Michigan Constitution. No state law that they are trying to use have wrote up about it, justified my Constitution. And to do is try to use state statutes, unconstitutional state statutes, but that doesn't justify my private property. Why it didn't justify depriving me of it then, and not continuing to deprive me of it now. I do not need to pay no money for it back from the towing place. Again, that's based on my constitutional and human and God-given rights to enjoy my private property. And there's no injured party now in the case. I want to mention that too. So the plaintiff has no standing against these so-called criminal charges. There's no standing because there's no injured party. And I have a U.S. Supreme Court case on that, so I'll move to dismiss the case on that. In addition, which also supports why it should be given it back. They have no, because as the standing is a necessary. This is word for word U.S. Supreme Court case called Rames. I may not be pronouncing it right. It's spelled R-A-M-E-S versus Bird, B-R-Y-D, 521 U.S. 11. Standing is a necessary component of subject matter jurisdiction. Then we go to another case. The requirement of standing, however, has a core component derived directly from the Constitution. A plaintiff must allege personal injury barely traceable to the defendant's allegedly unlawful conduct. Okay, and likely to be redressed by the requested relief. That's another U.S. Supreme Court case, Allen versus Wright. 468 U.S. reports, pages 737 and 751, decided in 1984. So again, that's personal injury is required by the plaintiff. There's no injured party. Meaning charges were to be dismissed, all of them, because all these three charges, nothing needs to be wasting the time to go to a jury for. All these charges, this cop wrote up board. It's undisputed that just by the nature of the charges allegation, that there's no injured party. No injured party, the plaintiff has no standing, and therefore they all must be dismissed, and that also further supports why my private property should be returned to me, and in addition to, like I said, my due process right. And I can't think nothing else to say now. I reserve anything else to say, though, if anyone else has something to say. If there's any dispute that it's not my private property, I'd like to hear that. Yeah, and that's it for now.
All right, Mr. Greco.
Yes, addressing each of the requests here, which I believe are a motion to dismiss the charges and the return of property or wrongfully impounded moped. Your Honor, the defendant has been charged with driving while license suspended, revoked, or denied upon information and belief. And looking at the record, it looks like it's revoked. He was operating a moped June 11th, 2023 in the city of Taylor. When he was pulled over by the officer, he was unable to produce a license or if you are under a certain age, but up to a certain age, I believe it's 15 or above, you can get, if you don't have a driver's license, a special moped driving permit. But the charge is appropriate, and therefore the motion to dismiss with respect to the charge should be denied. Number two, with respect to the impound, here we have a driver who's not able to operate what is classified as a motor vehicle under the motor vehicle code, this moped, and it's on the side of the road. We can't keep it there. He can't take it. He can't drive it. For safekeeping more than anything else, it gets impounded. At that point in time, Mr. Martin is able to go get the moped if he wants. Yes, he has to pay for it because it has to get taken into custody because we can't just leave it on the side of the road. There is an appropriate action that is not this motion to challenge the impound fees of the contracted towing agency for the police agency. This court has seen those many times before with respect to not the fees are appropriate or if the taking is appropriate. In this case, it looks like the motion is for the taking that's appropriate because there has been no action or motion filed with respect to area towing and the fees that it is charging or was charging at the time that he may have attempted to take it. So we request that the motions be denied in their entirety.
I have something to say in response to that.
Sure.
Okay, now, so first of all, I wasn't required to have any license, as I pointed out in my demand for dismissal of the case, because as the federal statute I've mentioned, first let me mention the state statute. It defines a motor vehicle as one just mechanically drawn. The Michigan state statute is unconstitutional And the definition is not complete because as the federal statute I cited, made by Congress, 18 U.S.C. 31 subsection 6 and 10, makes it clear the definition of motor vehicle by the federal statute is one mechanically drawn and used passenger property for profit, which I was not doing. They do not have evidence that I was doing that. Article 6 of the U.S. Constitution is clear that federal statute that is named off is supreme law of the land, okay, right along with the Constitution, and also mentions treaties of the United States, is supreme law of the land. Therefore, it overrides their state law statute that they're relying on. Therefore, the state statute is unconstitutional. It's not a complete definition of it. And also mentioned the U.S. Supreme Court case that I cited also supports this definition of motor vehicle, something we need a license for or not. Because as the U.S. Supreme Court said in the cases I cited, that the people have a right to travel. This is a long recognized right. Constitutional under the Due Process Clause, the right to life, liberty, or property. That's one of the liberties we are entitled to. A right, not a privilege. We need to request the DMV for as a lawsuit to make changes because of this. So cops are not relying on this, and people stop being harassed our right to travel. But anyway, it's the right to travel. And they said specifically, in the right to travel is as long as you're not doing it for profit, okay, carrying passenger property for profit, we do not need a license, registration, or insurance. The U.S. Supreme Court cases I cited, and there's many more that and there's many more exist out. Say the same thing. Don't need a license. The state statute is unconstitutional. And as far as paying a fee, I'm going to cite off a case right here. No state shall convert a liberty into a privilege, license it, and charge a fee therefore. Murdoch versus Pennsylvania, I relied on this case also. It's volume 319, United States Reports, page U.S. Supreme Court. You don't pay no money for the exercise of the right. You cannot be charged a fee, and you cannot convert a liberty into a privilege. But this is what's going on with the state statute. See, they're assuming everyone's driving a motor vehicle or not. See, there's a difference between a motor vehicle, which is just one used commercially for profit, such as a DoorDash driver, a taxi driver. That's when you're technically driving a motor vehicle. When you're not doing it for profit, which is what I was doing, going to Walmart or Joyride, whatever I want to do, go to work, that's not for profit. That is what's called traveling, and this is terminology from the Supreme Court themselves, along with other law mentioned. It's called traveling in my private property. There's a difference, there's a difference how it's used. That's one of the legalese tricks. Whoever excuse my terminology, whoever the scumbags was that made this stuff, because I think it was intentional. It's an intentional evil plan with this legalese that's being used. So the average person don't know what's going on. It's a shame. And they're trying to use this legalese trickery terminology to violate people's rights and trying to convert them into privileges by using words people know what they mean. Yeah, but so basically, once again, sum it up, I'm all within my right to travel. It's stealing my personal property. The state statute cannot justify stealing my private property, which is why that record should be represented criminal charges against the cop. Which I made asked him to file the charges on the cop for this, and he refused. So it's like he's also shown his discrimination and wants to prosecute non-cops, but you don't prosecute cops. And also finally, he did not Greco did not respond and therefore waived his response to my no injured party defense So therefore, we raised it, and I'm on that argument. And that'll be it now. I reserve my right to respond back to anything he may say that I haven't said already.
I've heard from both parties. Mr. Greco, was there anything further?
No.
So, Mr. Martin, through your oral argument and written briefs, you've raised a couple of issues. So let me address those seemingly in the order in which you raised them. So first off, let's talk about jurisdiction. Now, you argue that this court lacks jurisdiction over you.
Yeah.
Now, the question of whether a court has personal jurisdiction over a party is a question of law. And that can be stated in Poindexter versus Poindexter, and that's 234 Mishap 316, 1999. Typically, a plaintiff bears the burden of establishing jurisdiction over a defendant. However, a plaintiff, here the prosecution, only needs to make a prima facie showing of jurisdiction in order to defeat any motion to dismiss based on a motion to dismiss for lack of jurisdiction. That can be found in Jeffrey versus Rapid American 448, Mish 178, 1995. Before a court can obligate a party to comply with its orders or proceed to trial or do any of these proceedings, the court must have personal jurisdiction over a party. I think we all agree that that's true. Jurisdiction over a person may be established by a couple of ways: by way of general personal jurisdiction or specific or limited personal jurisdiction. Matter of fact, Michigan has two different statutes: a general jurisdiction statute and a specific jurisdiction or limited jurisdiction statute. So exercise of general jurisdiction is possible anytime that the defendant comes in contact with the forum state or the forum city or the forum body of government in such a way that the nature and quality are to enable a court to adjudicate any action against the defendant, even when the claim at issue does not arise out of contracts with the forum. Here, and if we look at the Michigan General Jurisdiction Statute, which is MCL 600.701, basically it states that the existence of any of the following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of the state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. And they point to three things specifically that I want to raise. One, presence in the governmental unit or city at the time when process is served, domicile in the city, and consent. Now, in the present case, Mr. Martin was physically within the boundaries of the city of Taylor at the time of the alleged criminal activity. When he was served with the ticket, the complaint. Second, Mr. Martin is also domiciled in the city of Taylor, which means he lives in the city of Taylor. The city of Taylor has ordinances regarding basically everything that the state does, and one of those is that you have to drive with a license. So I do find that there is personal jurisdiction over you. You availed yourself of the use of the streets here in Taylor. You live in Taylor, and you were served in Taylor. Therefore, you fall under the jurisdiction of the Taylor Court here, which is the 23rd District Court. As for standing, now standing is a legal term that people like to throw around, and well, you don't have standing. Standing is a legal term which basically determines whether the party can bring a lawsuit or has a right to do so. Standing is not about the issues. It's about who is bringing the lawsuit and whether they have a legal right to sue. So if you are suing your government, if you have no damage, if you have no harm done to you, why are you bringing a lawsuit? Here, this isn't about harm. This isn't about a civil suit. This isn't for some violation of rights. This isn't a claim for money damages because you weren't allowed to live where you want to live or marry who you want to marry or some other form of federal type of a situation that's a constitutional based or a tort based thing. This is a governmental unit doing their job under the Constitution to enforce the laws of their cities and states. The standing that they have is that they can show by preponderance of the evidence, they can show that there is probable cause that you committed, that there was a crime committed and that you committed the crime in the city of Taylor. That's all they need for standing. That's all they need is that, and along with personal jurisdiction. We've already established that there's personal jurisdiction. So as to your standing argument, there is no standing argument there. As for abandoning the vehicle or impounding the vehicle, under Michigan Compiled Law 257.252A about abandoned vehicles, it specifically states a person shall not abandon a vehicle in this state. So if you are arrested or you are using something as the instrumentality for committing a crime, well, you have a right to a trial, but that evidence has to be preserved, and they can't just leave vehicles laying around on the side of the road. As Mr. Greco rightfully stated, it's for the protection of the evidence, and it's also for a protection for you because, well, you can't just leave it on the side of the road because I know it's hard to steal a car, but if a moped, someone could just pull up, throw it in the back of their pickup truck, and now you're without a moped. Then you might have a lawsuit against the city for not doing their job of having it impounded and protecting your vehicle, protecting your moped. So that's why it's taken. Your moped is in safekeeping, and that's what they're supposed to do. So under the abandoned vehicle statute, they do have a right to do that when there's a crime committed. So now that brings us to our last point about the fact that you think that there's an underlying reason why this should just be dismissed outright, just a general dismissal, because you have a right to travel. You do have a right to travel. Matter of fact, the right to travel is a fundamental right. And we can freely use the roads, since why? Well, they're funded by tax dollars. However, the privilege to drive a vehicle can be conditionally granted even, based upon being licensed, based on following the laws that are set forth by the government. Driving is a privilege that a state can prohibit if they consider it. You do not have a constitutional right to drive a vehicle. You have a right, you can walk your happy self all over the state. You can Forrest Gump that thing all the way from one end of the country to the other. You can go ahead and jog your way back and then back again. You can't drive a vehicle if you don't have a license. I'm going to go to Florida. I'll give you a free, how about if I am, let's just say a hypothetical, I'm going to give you a free trip to Florida, Mr. Martin. All expense paid, and there's no air fees, because I have a private jet. But I'm the pilot. You gonna fly with me? I've never even taken a class about flying a plane. Don't even have a pilot's license. But you know what? I got a right to travel. I'll fly a plane if I want to. Does that make any sense? No. Why? Because planes can crash and kill people. Planes can crash and kill people. Cars can kill people. We want to make sure people are licensed to drive vehicles. Why? Because you're interacting with other vehicles that weigh thousands of pounds that are moving at rates of speeds 30 miles an hour and higher. There's literally a National Traffic Safety Administration. Why? Because it's a dangerous situation. Yes, we need it, and yes, it's necessary. But because of that, the driving privilege can be revoked. The right to drive a motor vehicle can be revoked. The right to have, trust me, I'm the most firm believer in the right to keep and bear arms. But if you're not mentally in the right state of mind, or if there's some sort of reason why everyone has agreed that, you know what, this guy should not be having any weapons. He's threatening to kill himself. You know what, for his own safety, let's get the weapons out of his hand. Now, the reason we have weapons, it isn't so we can go hunting, it's so we can protect ourselves against the usurpation by our despotic government of any of our rights. I get that, and I understand that. But at the same time, I'm not going to fly in a plane with a pilot who's never even taken a class, doesn't have a license. And that's why driving is a privilege. It's based on the character and nature of the activity. Yes, you can travel, you can ride a bike, you can pedal yourself around, you can walk anywhere you want to. You don't need to show your papers when you go from Michigan down to Ohio. Your papers, please. This isn't Russia. But you can't drive if you don't have a license, if that state requires it. And so, based on all of those things, based on the oral arguments that were presented today by both sides, based on the written briefs and answers to the same, I am denying your motion to dismiss. And I am denying your motion for the return of the moped. Now, after this case gets adjudicated, if it comes back where there's a not guilty on this case, then obviously, or even after it gets adjudicated, either way, your vehicle is always at any point capable of being picked up by area towing. If there's are any fees or storage fees associated with it, well, like Mr. Greco said, excuse me, ductwork here has never been cleaned since this building's been. That's the only place my allergies really kick in. If there's any, there is procedures in place for challenging the fees associated with such storage and towing, which is a separate matter. Okay, that's a civil matter. So this case is going to be set for a pretrial. We do have it. So now, as for this goes, since we're here, we're going to do an arraignment on the underlying charge. Mr. Martin, would you like a court-appointed attorney, sir?
Will not be accepting no court-appointed attorneys, as I will not be. They can fraudulently assume under the jurisdiction of the court. I invoke my right to be acknowledged as a sovereign, one of the sovereign people, as the U.S. Supreme Court said I have a right to do. Invoke my rights under the Republican form of government, Article 4, Section 4. Yeah, so I won't be accepting no attorney. And,
okay. So you do have the right to remain silent. Anything you say can and will be used against you at trial. Like I stated, you also have the right to an attorney. And at any point, if you'd like the assistance of an attorney, please don't hesitate to ask the court, and I will grant the same. It is alleged that on July the 11th of 2023, that you violated City Ordinance 3200B, which is commonly known and referred to as driving on a license that has been revoked. That's a misdemeanor punishable by 93 days in jail and or up to $500 in fines. As to that charge, how do you plead? Guilty or not guilty?
I'm not here to plead because I do not acknowledge myself as no defendant. That's fraudulent. I'm not a legal fiction.
Then I find you to, then I recognize you as standing mute as to the charge, and I'll enter a plea of not guilty.
Okay,
we're going to set this.
So,
Listen, we're not. Okay.
Have you entered a legal determination that I am not guilty of the charges?
Nope, I've just put in a plea right now at this time of not guilty, and we'll set this for a trial. The adjudication of your constitutional right to have a trial by judge or by jury, that will determine beyond a reasonable doubt if it's proven whether you're guilty or not guilty, pursuant to the Constitution. So I'm going to set this for a settlement conference. And you'll be given the date and time and the notice for the settlement conference. That'll be by Zoom.
Okay. I still have some things to say in response to what you said today. I still have some, still have some responses in response to what you said today. Such as, is it okay if I say it now?
Your response to
what you said today. After we made the argument. Some things, still have some things to say in response to that.
You're saying you would like to make a response to the ruling I made with regard to your two motions?
Yeah.
There's no response to be made to it. I mean, if you'd like to make a record, you're more than welcome to file any motions that you'd like under the court rules. But that was merely my ruling as to adds to the two motions that were in front of me, the motion for return of the moped and the motion to dismiss. So Mr. Greco, if you would put that in order.
Yeah, I object to it, and I have some more to say about that, and that is,
what I'm saying, sir, hang on, because, and I'm not trying to cut you off, I'm trying to protect your constitutional rights, because anything you say can and will be used against you. I just wanted you to be aware of that, okay?
I got
So
you.
what I'm saying is, I'm not gonna change the ruling today. If you want to file a motion for reconsideration, you can do that. You have the right to do that under the court rules. And we'll set it for a hearing.
All
right.
Now, I might not remember everything because you said a lot of different things, and it might be hard to remember everything and respond. But I still got some things memorized. I want to say now, so I want to say them. That is.
You do also, and like I said, at any time, if you'd like a court-appointed attorney, I can give you a court-appointed attorney. You could also order a copy of the transcript, so that way you don't have to remind yourself of anything. You can just, everything that was stated is already on the transcripts.
That is, they try to charge money again. Again, it's a big monetary thing. You know, they're trying to turn rights into privileges, charging money, and I don't. Money for that.
It's not about charging money. When I go to the store, I don't just get to walk out with bread. I mean, I got to pay for the bread because somebody made the bread. So somebody has to type a transcript. So, well, this is also on YouTube. So for all my YouTube watchers out there, hey, how you doing? God bless America. You can also watch a copy of YouTube. It's supposed to be deleted by 8 o'clock tomorrow morning, but God knows it won't be because it's my cases. So you'll be able to watch it probably for as long as you ever want to. So you can see it again.
Make sure I check it out. But anyways, I still want to finish. Let me finish what I have to say. Let me respond to what else you said. Now, you mentioned we have a right to travel, but we don't have a right to drive a motor vehicle. Okay, now, on that terminology, travel by right and drive a motor vehicle is not the same. And I can be controlling my moped, okay? I can be controlling a motorcycle car by right. It's not if I only walk. Or didn't say that. Traveling by right means as long as I am not carrying passengers or property for profit. I'm doing my private vehicle, which what I was doing. I wasn't working for DoorDash. There's no evidence. I wasn't working as a taxi driver doing nothing else. I was therefore traveling by right. If I was in a car, same thing. If I am not carrying passenger property for profit,
It's incorrect. You're incorrect.
I'm
just telling you, you're incorrect. You're incorrect. I've taught constitutional law for almost 20 years. You're incorrect. You don't have a right. You do not have a right to travel by any means you choose. So that's the place I'm going to go buy myself a helicopter. I'm going to fly to work every day. No license, helicopter, and then I'll just call myself a Uber helicopter. I'm sure everybody would like to show up at the parties in a helicopter. You can't do it. You have to have a license to drive because it's a dangerous activity. You can walk anywhere you want to. You do, I agree. You have a right to travel, but it's not by any means you choose.
Obviously, the right to travel means it doesn't matter how a human cannot dictate. You can.
Sir, I have other cases to get to. So I'm not trying to cut you off, but if you want to file a motion for reconsideration, you're more than welcome to do so.
You are coming somewhat short because I still want to talk. I have the First Amendment right to speak, and I will continue.
You do have a First Amendment, again, there you go again. A First Amendment right. A First Amendment right to speak doesn't mean you have a First Amendment right to speak. It means that you have a First Amendment right not to have the government interfere with your right to speak. That means that if you want to go stand in someone's sidewalk and give a speech or hold a sign, you can do that. The government can't stop you from doing that. But if you want to walk around naked, the government can stop you from doing that, even if you call it free speech. Why? Because it's indecent.
Well,
there's rules to everything. Everyone says, well, I have a right to say what I want to. No, you don't. Not in a private situation. So, like, if you're at someone's house and you're talking about whatever, there's like, hey, stop that, and you're like, well, I have a right to say what I want to. No, you don't. Not against private citizens. See, everyone just misuses and throws that word out so quick that they don't even know what they're talking about. It's kind of like right to travel. But anyway, if you have a motion for reconsideration, the court will review that and set that for a hearing. But I've made my determination today with regard to your motions, okay?
Well, I'm also gonna make, well, because you made your determination, which is unfair, unconstitutional, I'm gonna make a motion to disqualify you, which I then, therefore, if you're gonna deny that too, I request you send it to the State Court Administrative Office, that you're supposed to do under the court rule. That you showed your bias by denying my constitutional rights, which you took no foothold, such as denying my right to travel, my right to my private property by using the state can make money off me and use their state statutes to my constitutional rights. I don't think so. That's not true. And they cannot charge money for my private property. No state law, you should know that. They cannot use that as a reason to violate my constitutional rights and charge me money for my private property. No, that is criminal stealing, larceny. It's violating my constitutional rights. You're supposed to be upholding my rights as you took also, not violating it, working, conspiring with the state, making money, and that's all it is. It's like a eco thing going on. You prosecute, rich off it.
All right, so you made the same argument several times, and I do note that for the record. Your objections are noted, but then again, so my response to that is I'm not changing my ruling with regard to the motion to dismiss or the motion for return of the moped. There are other options that you have available. If you think you need to file a motion to disqualify, please file the motion and we'll set it for a hearing. If you think you'd like to have a motion for reconsideration, again, you can get a copy of the court rules. You can just Google the court rules, you can come up right there, or we might already have a copy at the library. But I make sure that everybody follows the same rules and how things go. And just because someone gets ruled against at a motion hearing, we don't just keep talking about it until the judge changes his mind. That's not how it works. There's procedures in place, and I'm just making sure that all of your constitutional rights are been afforded to you. So you have several options of how you can proceed, but right now this case has already been heard and decided, and we're going to be moving. The court's going to be moving on to other cases that need to be taken care of.
Is okay. I'm going to correct you. That's not totally correct what you said. It ain't just I just keep talking and not repeating myself. When you say things, you're saying something new that I haven't had a chance to say or respond to before you say it.
There isn't a response, sir. It's my ruling. It's not a response. There's no response necessary.
That's my due process right to respond. What do you mean?
No, your due process is the fact that you had the right to come in here. Due process is affording someone both opportunity to be heard and the venue to be heard. Here we are in the court. I allowed you to come in. We're here by Zoom. You had the right to file all your paperwork. All your paperwork was handwritten. And you know what? I accepted all of it. Why? Because that's part of due process. I gave you the benefit of the doubt of being someone who's improper. That's fine. Not a problem. I heard your motion. I allowed you to make oral argument on your motion. I afforded due process to Mr. Greco, where I allowed him to make a response on the record. I asked you right in the beginning, is there anything you wanted to say for oral argument, or did you just want to stand on the brief that you filed? And you went ahead and made oral argument. That's allowing you due process. This is all everybody playing the game. This is everybody doing their part and having the opportunity to play the game. And that's what I afforded every single individual. I take offense if there's to any comment that you state that I'm trying to railroad you or any kind of thing, because you know what? The Constitution is the most important thing to me. The Constitution is what gives every one of us freedom. Constitution is when I get woke up in the middle of the night to sign a search warrant. God bless them. God bless them. Thank you for waking me up in the middle of the night to sign a search warrant. You want to know why? Because that's the Constitution breathing. That's the Constitution doing what a bunch of guys back hundreds of years ago said, you know what? This is what freedom is about. So you know what? I take offense to anything like that. So if you'd like to file a motion for disqualification or for reconsideration, please do so. But at this point, your case has been heard. A decision has been made. Thank you, Mr. Martin, and have a good day, sir.
But, well, okay, again, you did allow me some time to...
Well, folks, there we have it. Now, there is a lot to say about this one, so definitely keep your eyes on this channel. Hit that subscription button, hit the bell icon so you'll be notified when I go live, and myself and Colin are going to have a chat about this one and break it down. I really hope you enjoyed it. If you did, make sure and hit that thumbs up. And a massive thank you once again to Colin. Sodja, folks.